We are not finished. We are not finished. We are not finished.
The submitted firearm brace, when attached to a firearm, does not convert that weapon to be fired from the shoulder and would not alter the classification.
Not one more! Not one more! Not one more!
Distribution of 10 to 40 million of these braces and the implementation of your rule. Did Congress pass a law?
Today, we say more than enough. We say more than enough.
A lawsuit opposing the ATS's new regulation on stabilizing braces, sometimes referred to as pistol braces, this new regulation. In response to the final regulation that was formed and published, the pistol brace rule makes it so that practically any handgun with a brace attached will now be regarded as an SBR and hence subject to the interphase limits. Factoring criteria for firearms. ATF Final Rule 2021 R08F factoring criteria for firearms with attached stabilizing braces, which clarifies when a rifle is designed, manufactured, and intended to be fired from the shoulder, was approved by the Attorney General on January 13, 2023. On January 31, 2023, the final rule was released in the Federal Register. In order to determine whether a firearm would be regarded as a rifle or short-barreled rifle under the Gun Control Act of 1968, or a rifle or firearm subject to regulation under the National Firearms Act, the National Firearms Act, or the Gun Control Act of 1968. The factors ATF would take into account when evaluating firearms equipped with a purported stabilizing brace or other rearward attachment. A weapon that is equipped with an accessory, component, or other rearward attachment, such as a stabilizing brace, that provides surface area that allows the weapon to be fired from the shoulder is included in the term designed, redesigned, made or remade, and intended to be fired from the shoulder, as long as other factors as listed in the definition indicate the weapon is designed and intended to be fired from the shoulder. This restriction does not apply to stabilizing braces that are specifically created and intended for use by people with impairments rather than when shouldering a rifle. Such stabilizing braces are made to fit the arm rather than serve as a buttstock. When it was published in the Federal Register on January 31, 2023, this regulation became operative. If the stabilizing brace-equipped firearm is a short-barreled rifle, the concerned person has 120 days from the date of publication, or until May 31, 2023, to register the firearm tax-free. The following additional compliance options are included in the final rule. Remove the short barrel from the gun and replace it with a 16-inch or longer rifled barrel. Remove and discard the stabilizing brace forever, or modify it so that it can never be reattached. Deliver the weapon to your neighborhood ATF office. Destroy the weapon. ATF's expansion. The Alcohol, Tobacco, Firearms, and Explosives Bureau has successfully carried out its plan to turn millions of lawful gun owners into felons in the interest of public safety by reclassifying pistols with stabilizing braces as short-barreled rifles. This was done in the name of promoting gun control. This has the consequence of adding more people to the National Gun Registration, which is against the Constitution. Stabilizing braces are an accessory that may be attached to pistols and provide the operator with assistance in maintaining arm balance. The technology, which was initially designed to help people with disabilities, is becoming increasingly popular among slayers in the general public. These slayers utilize the devices to turn handguns into shoulder-fireable weapons, which was not previously an option. You must now overcome a significant obstacle if you do not want to be subject to monetary penalties and/or time spent in jail. People who want to add stabilizers to their pistols must comply with the heightened regulations on those dangerous and easily concealable weapons, as the Department of Justice initially advised on June 7, 2021, and as was put into effect on January 13, 2023. This law was put in place to prevent people from carrying dangerous and easily concealed weapons. According to the new regulations, any handgun that has been modified with such a brace is now considered to be a short-barreled rifle.
To run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
I want to be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
According to the Department of Justice, the National Firearms Act has imposed requirements on short-barreled rifles because they are more easily concealable than long-barreled rifles, but have more destructive power than traditional handguns. These requirements have been in place since the 1930s. In the statement, it is said that those strengthened regulations go beyond background checks and serial numbers, and include taxes and registration requirements that involve background checks for any and all transactions, including private transfers. A tax in the amount of $200 must be paid by everyone who either makes or purchases a gun with a short barrel. A generous grace period of 120 days has been extended to all affected manufacturers, dealers, and individuals, during which time they can voluntarily comply with the law by registering the firearm, removing the brace, handing it in to the ATF, or destroying it. Attorney General Merrick Garland directed the ATF to address the issue of stabilizing braces within 60 days in April 2021, after meeting with President Joe Biden. As a direct consequence of this, the Department of Justice wasted no time in making the proposed regulation public the next month. Stephen Dettelbach, a former advisor to President Obama and currently the acting administrator of the Alcohol and Tobacco Tax and Trade Bureau, was also selected by Vice President Joe Biden earlier to run the ATF. Although the Bureau claims that the new regulation will not affect stabilizing braces that are objectively designed and intended as a stabilizing brace for use by individuals with disabilities and not for shouldering the weapon as a rifle, there is no objective standard listed for what is permissible for disabled people to carry or what is intended as an aid. Additionally, there is no objective standard listed for what is intended as an aid. Unconstitutional policy from FDR. Politicians with authoritarian tendencies have a long history of advocating for the government to require all gun owners to register their firearms with them. In 1934, when President Franklin D. Roosevelt was considering making it illegal to own fully automatic guns, the Department of Justice vehemently opposed the idea, arguing that doing so would violate the Second Amendment. Instead, the administration has been pushing for legislation that would require the registration of fully automatic weapons, short-barreled rifles and shotguns, as well as firearm sound suppressors. This is done in an effort to strike a compromise with the opposition. The National Firearms Act of 1934, which was passed into law as a result of this idea, has been referenced by the current Department of Justice and the ATF as rationale for expanding the National Gun Registry to include law-abiding citizens of the U.S. The fact that Roosevelt selected Homer Cummings for the office of Attorney General, who was instrumental in the writing of the NFA, demonstrates the degree to which he was dedicated to the creation of a national register for all weapons. Cummings wrote in 1938, the same year that he supported separate handgun registration legislation, "Show me the man who doesn't want his gun registered, and I will show you a man who shouldn't have a gun." Cummings was a proponent of separate handgun registration legislation. About half a century later, in 1988, President Ronald Reagan signed the Firearms Owners Protection Act, which made it illegal for the federal government to maintain a national firearms registry. When it comes to the Second Amendment, Ronald Reagan made some mistakes here and again, but all things considered, this was a brilliant plan that gun control proponents regrettably ignored. Implications of criminalizing tools. Stabilizing braces, which are worn by disabled and able-bodied people to improve balance and precision, have been the subject of expert warnings about the dystopian repercussions of criminalizing them. Few seem to realize that stabilizing braces for pistols were originally designed to allow wounded and disabled veterans who may have lost the use of part of their hand to hold handguns. Dr. John Lott, president of the Crime Prevention Research Center, wrote for Real Clear Politics. They resemble a strap that is fastened to the pistol. Criminals frequently consider disabled people as easy targets. Therefore, stabilizers make it simpler for them to protect themselves. He quotes Rick Cicero, a handicapped veteran who was serving in Afghanistan 13 years ago when he was injured in an explosion and lost his right arm and leg. After the DOJ proposed the rule in 2021, Cicero told Spectrum News 9 that if they removed it, they would be breaking their own law because it was created and used by people just like them. Cicero, who instructs other wounded veterans on how to pick up a gun again, continued, "The most important thing to me about this brace, this whole aspect, is another avenue of getting injured veterans out of the house." Dr. Lott asserts that the two incidents highlighted by Biden to support the new ATF policy were not even true instances of braces being used to more effectively commit a crime. Lott stressed that President Biden, who used a crime in Colorado in 2021 as reason for designating pistols with stabilizing braces as mash guns, is responsible for these events. During the slaying, a slayer attacked customers in a grocery store while utilizing a pistol stabilizing brace.
That Bruin is a thing from which the public must be protected. This is simply not true.
So other families will not have the experience and the pain and trauma that they had to live through.
For too long, states like New York told millions of citizens that their right to armed self-defense ended the moment they left their homes.
She proves you can run for office ending gun violence in the South and you can win.
Lawful gun owners are not the driving force behind criminal gun violence, and this is particularly true of concealed carry permit holders.
AK-47 is an automatic Kalashnikov model of 1947.
At the same time, as I outline in much greater detail in my written submission, they play a significant but underappreciated role.
You can prevent the next tragedy. You can save life. You can save families in the process.
Lott claimed that 10 individuals were shot dead at close range in a grocery store in Boulder by Ahmed al-Alwi. In 2019, Connor Betts committed another incident using a pistol brace in Dayton, Ohio. Lott emphasized that these two occurrences were exceptional and that neither slayer had any trouble managing their firearms because all of the bullets were fired at close range. Lott claims that there is no proof that the brace had a major impact on their ability to execute the attacks. Furthermore, he said that the use of these braces by people with disabilities or others has not resulted in a noticeably higher rate of criminality. All of this is related to Americans' inalienable right to own guns for personal defense. As Brett Cooper of FEE noted when the rule suggestion was made, James Madison was against a kind of government where overarching bodies could change the law as they saw fit. The Founding Fathers stated in Federalist No. 48 that the accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one, a few, or many, and whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. Cooper emphasized his worry about the current circumstance, saying that it is an obvious illustration of what is happening right now. He emphasized that all Americans, including those who are not specifically a part of the affected gun community, should be concerned about this covert campaign to seize power. Stop to Biden's ATF pistol brace rule. U.S. Senators Roger Wicker, Mississippi, and Cindy Hyde-Smith, Mississippi, have co-sponsored a resolution of the Congressional Review Act in an effort to prevent the ATF from enforcing an anti-Second Amendment pistol brace rule during the administration of former Vice President Joe Biden. There are 45 sponsors for SJ Res 20, which would abolish the ATF rule titled Factoring Criteria for Firearms with Attached Stabilizing Braces. The sponsors of this resolution include the senators from Mississippi. The law would classify handguns as short-barreled rifles if they included accessories that could convert them into short-barreled rifles, despite the fact that many injured veterans and other Americans rely on stabilizing braces to control their firearms. Wicker has voiced his opinion that the recently implemented law regarding pistol bracing constitutes a severe breach of the Second Amendment rights of American citizens. He criticized the administration of Vice President Joe Biden for routinely breaking the restrictions that were established by the Constitution, and he promised his support to gun owners who are fighting against the regulation. Commenting on the activities of the ATF during the administration of Vice President Joe Biden, Senator Hyde-Smith stated that the agency's fixation on drafting rules frequently resulted in encroachments on the rights of law-abiding gun owners. She voiced her opinion that she believes the rule accomplishes very little to effectively address the issue of violent crime. Hyde-Smith made a plea to her fellow senators for them to provide adequate support in order to thwart the implementation of this counterproductive and pointless policy. According to a rule established by the ATF, law-abiding gun owners run the possibility of spending up to 10 years behind bars and paying fines totaling tens of thousands of dollars if they fail to register firearms equipped with stabilizing bracing with the ATF. Those who own firearms but have not registered them with the ATF are required to either destroy them, hand them over to the ATF, or remove the brace in such a way that it cannot be reattached. The decision that pistol brace attachments do not change a handgun's classification from that of a pistol to that of a rifle was made by the ATF in 2012, while the Obama administration was in power. In spite of this, the DOJ was requested by the Biden administration to design a rule in 2021 in order to define the circumstances under which a handgun that has been attached with a brace should be categorized as a rifle. The DOJ issued the statement regarding the final rule for stabilizing braces earlier this year. The primary advocates of SJ Res 20 were Representative John Kennedy and Representative Roger Marshall. The U.S. Representative for Georgia, Andrew Clyde, will introduce a comparable resolution to the House of Representatives. FRAC and 25 states sue ATF. SB Tactical, along with the Firearms Regulatory Accountability Coalition, B&T USA, Rick Cicero, and a coalition of states, has filed a lawsuit challenging the legality of a federal rule that retroactively bans or requires registration of millions of pistols equipped with stabilizing braces. The lawsuit was filed against the ATF. They contend that other federal statutes, which were passed by Congress, cannot be followed because of this rule. Jeff Creamer, President and Chief Executive Officer of SB Tactical, criticized the activities of the ATF, arguing that it constitutes an undue exercise of the Bureau's authority and puts millions of law-abiding handgun owners in legal jeopardy. Creamer's comments were made in response to the ATF's actions. Creamer referred to it as the most extensive plan for the registration of firearms in the annals of U.S. history. The lawsuit was initially filed in the U.S. District Court for the District of North Dakota by FRAC in its capacity as the main plaintiff. In addition, a coalition of 25 state solicitors general, led by the Attorney General of West Virginia, Patrick Morrisey, and the Attorney General of North Dakota, Drew Wrigley, have joined the complaint in an effort to demand responsibility from the ATF.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Get on the ground now!
I'm a federal agent.
917-110-3.
I'm a federal agent.
Get on the ground!
Real background checks could stop a lot of illegal guns going in different places in the country.
Shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
The president and CEO of FRAC, Travis White, made reference to earlier instances, such as Cargill versus Garland, in which FRAC, SB Tactical, and B&T USA all participated as amici curiae. He mentioned that the Fifth Circuit Court of Appeals had decided that such regulatory overreaches go beyond the ATF's power, and he mentioned that the court's decision was acknowledged. White voiced confidence that the courts would continue to hold the ATF accountable for their regulatory overreach and shifting viewpoints. White expressed optimism that the courts will continue to hold the ATF accountable. SB Tactical has expressed gratitude to the NRA for the important support and help they have provided throughout the dispute. They also encouraged irate manufacturers to join FRAC in their fight against the arbitrary and capricious regulatory approach taken by the ATF. FRAC versus ATF and the pistol brace rule. A recent order and clarification released by the Fifth Circuit Court of Appeals in the Mock versus Garland litigation stated that an injunction was required in the case. In an effort to stop the ATF from enforcing the pistol brace rule, the FRAC and SB Tactical have filed a lawsuit against the agency in 25 different states. During the time when oral arguments were being held in the pistol brace case by the Fifth Circuit, the FRAC lawsuit, which has been an anomaly, was being handled by a federal district court in North Dakota. As a result of the clarification provided by the Fifth Circuit, all of the lower courts located within the Fifth Circuit have now granted temporary restraining orders against the defendant. The plaintiffs in the complaint against FRAC have provided the mock order and clarification to the federal district judge in North Dakota as further support, encouraging the judge to issue a similar injunction, at the very least on a temporary basis. However, in contrast to the other courts, the FRAC court has declined even temporarily to make a decision about the case. It is thought that the recent brief that the ATF filed in the FRAC litigation is the reason behind the delay in entering an injunction against the ATF pistol brace ruling in favor of the plaintiffs in the FRAC case and the 25 states that are participating. The action was brought against the ATF by FRAC. These states would receive a large amount of protection if they were granted a favorable order. The plaintiffs contend that the rule issued by the ATF is a final agency action that goes beyond the statutory authority granted to the ATF. They argue that the rule illegally regulates pistols and other firearms that are equipped with stabilizing braces, despite the fact that the National Firearms Act and the Gun Control Act do not seek to regulate such weapons. They are referring to the fact that the National Firearms Act and the Gun Control Act do not regulate such weapons. On the other hand, the ATF contends that firearm makers have heavily marketed devices known as stabilizing braces throughout the course of the past decade. These devices are intended to attach to the rear end of a handgun that has a rifle receiver but no buttstock. Although it is stated that these braces will assist with one-handed firing by bracing against the forearm, the makers typically design them to resemble shoulder stocks, which allow pistols to be converted into shoulder-fired guns. This is despite the fact that these braces are advertised to assist with one-handed firing. Arguments and response. In the case brought against the FRAC, the ATF is defending its newly implemented regulation regarding pistol braces by stating that the rule is merely a clarification and does not constitute an extension. In addition to this, they argue that the plaintiffs do not have the legal right to bring this action because they have not provided evidence of their braced firearms or offered them for testing. Following the ruling handed down by the Fifth Circuit, both sides have presented their arguments regarding whether or not a sweeping injunction should be granted. However, in light of the current response provided by the ATF to the simulated supplementary authority, it appears that the FRAC court will not be able to grant any relief at this time. The ATF contends that the plaintiffs are required to provide details regarding the types of firearms that they personally possess, and the judge must then decide whether or not such firearms qualify as short-barreled rifles.
Giving domestic violence abusers a license to kill and essentially preventing the government from doing anything at all about it.
The sensitive places doctrine was not at issue in this case and still exists.
But then it released him, apparently believing that a civil restraining order instead of pretrial detention was the best way.
He went on to say he looks forward to a quick resolution in the Texas Senate.
Predictably, Mr. Rahimi soon thought, to hell with your restraining order.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
Aggravated assault with a deadly weapon against a different woman using a gun that he wasn't legally allowed to own, but obtained anyway.
They maintain that the rule is meant to address the widespread circumvention of restrictions governing the production and possession of SBRs, and that this is the intention of the rule. According to the ATF, the rule in question is neither new nor enlarged. Rather, it serves the purpose of preventing illegal violations of laws that are already in place. On the basis of the order issued by the Fifth Circuit, the plaintiffs, who are represented by FRAC and 25 different states, demand for a sweeping injunction. They have not provided their brace pistols for testing, which the ATF notes as a lack of proof on their end. In spite of this, it appears that the ATF's reaction to the sham additional authority has prevented the FRAC court from giving any form of relief, thus halting the court's orders. The notice that the ATF has sent to the court is a response to the notice of additional authority and compliance deadline that the plaintiffs have submitted. They contend that the rulings made in Texas, which sided with the plaintiffs and backed their arguments, go counter to the precedent established by the Eighth Circuit and the Supreme Court in regard to the standing and irreparable harm. The ATF contends that the Texas court based its decision exclusively on the finding of irreparable loss made by the Fifth Circuit, without considering any substantial evidence. In addition, the court decided that Texas had standing and had demonstrated irreparable loss based on compliance costs, despite the fact that there was a dearth of solid information to support these accusations. FRAC lawsuit and ATF's blocking of injunction. The finding that the state of Texas could not invoke its sovereign or quasi-sovereign interests as a basis for relief was repeated by the district court in its earlier ruling. The injunction, if there is one, should only be binding on those parties who are directly involved in the dispute, the judge emphasized. In particular, the court made reference to an earlier judgment in which an enlargement of the injunction to cover all residents of Texas was denied, thus limiting its scope to the state. its employees, and its agents. The ATF is using this ruling as leverage in their argument against broadening the scope of the frack case to encompass all residents of the 25 states that are implicated. Due to the involvement of 25 different states, the ATF is portraying the lawsuit against frack as an anomaly in comparison to the other cases involving pistol braces. They argue that the ATF's attempt to halt the injunction is a feeble one, yet they acknowledge that it has caused the court to be hesitant to impose an order while the sham lawsuit is still continuing. The mock order and explanation that is currently in effect have provided some protection for members of a variety of organizations, alleviating the immediate pressure that was being placed on the North Dakota court to make a quick ruling. The outcome of the Fifth Circuit's decision in the mock case is anticipated to have a significant impact on all related cases, including frack. Once the decision is received, it is expected that the frack lawsuit will proceed more assertively. The current status of the pistol brace issue is awaiting the ruling of the Fifth Circuit, which will determine the direction of the cases. That's all for this video, folks. See you next time.